Cleveland is one of 250 chapters in SCORE. There are around 12,000 people across the nation who are SCORE mentors. SCORE is the largest network of free volunteer small business mentors in the nation. No matter what stage your business is in at SCORE, we have a mentor for you, and you can easily request a mentor to help you start, grow, or transition your business today. Later in this brief set of slides, I will show you a QR code where you can capture a link to go to the SCORE website, and also then capture a link to request a mentor. SCORE's mission is to foster vibrant small business communities through mentoring and education. We aim to give every person the support they need to thrive as a small business owner. Small business drives our national economy through business formation, job creation, and wealth building. Small businesses are critical to vibrant communities in our community. SCORE volunteers give freely of their time, energy, and knowledge to help others. We are open to all entrepreneurs from all walks of life, and we make no distinction. We have a mission of empowering all entrepreneurs to succeed. In 2022, the last year for which we have data, we'll have more data in 2023 in a month or two. We helped started 501 new businesses, 808 jobs were created, and 7,500 chapter services. These are mentoring sessions and workshop attendees. We service Cuyahoga, Lake, Lorraine, Geauga, Ashtabula, Huron, and Erie counties. Because our work is supported by the U.S. Small Business Administration and a few generous sponsors, and because we have 10,000 volunteers, we are able to deliver all of our services at no charge. This is the quick look at the SCORE website, which I'm going to move on here. And let's go here. And these are the QR codes that I mentioned. So if you have your phone handy, on the left is a QR code, which will give you a link to the home page. And on the right is a QR code to request a SCORE mentor. Now, because you're attending this webinar, you will get a link to a recording of this webinar, and you can always come back to this and look, or you can just go to the SCORE homepage. And the best way to find it is to open up your search browser and put in this term SCORE Mentor Cleveland. And make sure you have all three words, because if you just say SCORE Cleveland, you're going to get sports data, which is nice, but not going to help you getting a mentor. So that is my little story there. I'm going to close this. I'm going to stop sharing my screen. And I'm turning it over to Tyler, who will introduce himself.
Hi, everyone. Go ahead and get my screen up here now. Slideshow. Switch this over. I think it should be showing everything now. So this is the legal series, business contracts and insurance. We're going to talk about mostly business contracts, and then maybe at the end talk about insurance. As he mentioned, my name is Tyler Bewley. I'm an attorney. I have experience both in-house counsel and at a law firm. So because I've been in-house counsel, I'm uniquely qualified to sort of talk to small businesses about how the legal, their legal challenges affect them, their day-to-day. Because when you're in-house counsel, you're really working with the business, and you're part of that business team and not just outside legal counsel. So a lot of my experience is from that perspective. I've been in-house for an automotive dealership group, and then I'm now in-house for a commercial real estate group called Chase Properties, where I do real estate, a little bit of business, corporate governance, those kinds of things, but mostly leasing and acquisitions. But a lot of my past has been mergers and acquisitions, real estate, and general business legal advice, and of course, lots of contracts. So always have to give this disclaimer at the beginning. This is for general educational purposes only. I cannot give legal advice on behalf of SCORE or without a lawyer-client attorney privilege established here tonight, which will not happen. So none of this should be considered legal advice. You should consult your own attorney about each of your own very specific legal issues. And as I said, no attorney-client relationship will be established here tonight. Should you need an attorney, SCORE has referral networks, as well as the Cleveland Metropolitan Bar Association also has referral networks. So please do not, in the short time that we're going to be here, please do not put your legal questions in the chat. I will not be able to answer those. All right. So what to expect in this presentation? You're going to learn about various contract provisions. These are going to be high-level basic concepts. Different types of contract provisions. So sort of those ones that appear, I think, a lot or sometimes for small businesses, and that specifically can trip you up, right? What in those contract provisions should matter to a business owner, right? What stuff you should negotiate, where there might be room to negotiate. And then very end, we're going to briefly touch on insurance. And spoiler alert, you won't become a business lawyer after this presentation. It takes years of studying, practice, and taking the little test called the bar exam. But why is it important to understand your contracts? Well, first off, ignorance of the contents of the contract is typically not a successful defense. So you'll hear the phrase ignorance of the law is not a defense, right? Just because you didn't know what the contract said and signed it, that's not going to be a defense when somebody goes to enforce and collect on the contract. And if you've signed on behalf of a business versus personally, and the contents of the contract have a business purpose, you're almost always going to get a less favorable treatment under the law and under statutes, common law, because those consumer protection laws do not typically apply to business transactions, and the courts look to you as a business owner to be savvy, right? To have business savvy and to understand the things that you're signing. So for example, the laws against many of the laws against usurious interest rates, so interest rates that are super high, those don't apply to businesses. So I see a lot in leasing of equipment contracts where they don't even have to disclose what the interest rate is to you, nor do they have to even disclose that they're charging you interest. They'll say it'll appear a lot more nuanced, and it'll just appear in the monthly payment. So it'll just show you like how much the cost of the equipment is, how much you're paying in monthly payment, and then what your final payment is. Usually those like $0 or dollar contracts, right? And the only way you'll find out that there's interest is that if you look at the actual cost of the equipment and look at the monthly payment, and then you do the calculations, you realize there's a whole bunch of interest built in there. So the most important thing you can learn from this presentation is read the contract. And if you don't understand something, ask somebody. Ask another business person ask a SCORE mentor. Some of these aren't complex legal concepts. It's just a different language, different lingo. So read the contract. So I sort of touched on this, contracts versus statute versus common law. Okay, what do I mean by these three things? Well, this is where the law is coming from in a contract. So you can have what the contract says, so what's agreed by the parties, although not everything in a contract is always enforceable, which we'll get on in a second, things that are waivable. And then there's statutes, and those are going to be things that are passed by the state and federal governments and are codified, right? So consumer protection laws, right? Those are statutes, right? It'll say what you can and cannot do. And then common law is the law that's generated from courts via opinions of those courts over time, right? So there's common law that goes all the way back, right? Hundreds of years ago. The statute, even if it's not stated in the contract, it might apply. And then The other thing you should watch out for is that sometimes contracts will attempt to waive certain statutes. So you might, by default, have certain statutory protections as a business in certain contract situations. For example, under a lease, you might have certain protections as a tenant in eviction and those kinds of things. But in some circumstances, in certain states, you can actually waive those, affirmatively waive them. And what's trickier is sometimes they'll put it in there and they'll say, you waive, this section of the statute, but they won't tell you what the statute is. They won't actually tell you what you're waiving, and that can, really decrease some of your rights that you would otherwise have under the law. And same thing here under common law. Even if it's not stated in the contract, it might still apply. All right. So types of contract provisions we're going to talk about today. The intro paragraph, recitals or background. Sometimes people refer to those as the whereas clauses, definitions, declarations, statements of a contract, representations and warranties, conditions, covenants, rights, discretionary authority, and then the signature block. So these are all the things that make up a contract. These are the types of sentences, right? Sentence structure. That's what makes up the contract. These all have different kinds of meanings. So we're really going to get down into the nitty gritty of like the English language and how legal people write, how lawyers write, and what those things mean generally. Okay. So at most contracts, you'll have some sort of intro, right? We got to define who the parties are. Who's this contract between, right? When's the effective date? Sometimes you'll see the addresses, the company names, individual names. And then you'll see sometimes these quotation marks with parentheses around them. All those are that we call them in-text definitions. So this contract purchase agreement. So the title of the document must be contract purchase agreement. And what that in-text definition there is doing is just shorthanding it to the agreement. So then every time you see the capitalized A agreement, not lowercase agreement, but uppercase agreement, that is referring back to the name of this document, the contract purchase agreement. It's referring to the whole document. Because if you see lowercase a, that means that it's not referring to this specific agreement. It's just referring to any agreement out there. Same thing here with effective date, ABC, XYZ. It's to shorten that and to refer back to it. Definition sections. So if you don't have the in-text like that's shown here at the bottom of the page, you can also have definition sections by themselves. You'll usually see these in bigger, larger agreements, where more money's at stake, that kind of thing. And so you're really getting down into, defining what a business day means, right? Super specific on things. And same thing, if you see that pop up again in the agreement, business days with a capital B and a capital D, that means it's referring back to that definition. Versus if you see it without that, it means it's just business days and it's open for interpretation still. Recitals or background. Like I said, these are referred to sometimes as whereas clauses. This sets up the agreement. It says, hey, this is what we were doing before. This is the history of the deal. This is what's happened already. Most of the time, these aren't enforceable. Sometimes they'll put definitions in these. If you don't put a clause in the agreement that says that the recitals or the background are enforceable, then usually they're not. That doesn't mean that the definitions aren't enforceable, but those provisions in the whereas section are not enforceable by themselves. So, for example, here, whereas seller is engaged in the business of selling widgets. That doesn't mean that seller is representing or warranting that they sell widgets or that they must sell widgets. That does not mean that, right? It's just saying, hey, this is a business that sells widgets. It looks like there's a assignment and assumption here with their assets and liabilities. That's what's happening. It just sets up the contract for the reader to tell them what's going on. It's especially important for the history if a lot of things have happened since then. So it's really important in amendments to agreements. So if you got a lease and then you've got 3 amendments, you might see a longer whereas section that says that, hey, this is the lease, this is when we signed it, this is an amendment we did, this is another amendment that changed these things, and now we want to do these things and change these things in the agreement. So a declaration, easiest way to say it, it's a statement. You're just saying something, you're stating a fact as to which the parties agree. So it's just to establish policies, create definitions in an agreement, sort of what we've already talked about. Questions you should ask yourself to determine whether it's a declaration: is the business term a definition? Does it establish a policy? To determine if it is a declaration, ask, would a party want a monetary remedy if it were not true? If yes, it is not a declaration. And so you see up there, the remedy is NA, because declarations don't have remedies, right? Like I said, if the person's not selling widgets in that earlier example, there's no remedy there. It's not enforceable that they're not selling widgets. They're just saying, hey, we sell widgets. So another example down here is just another definition. Purchase price means 200,000. That's all it means. Representations. Now we've gotten to our first item that has a remedy to it. Similar to a declaration, it is a statement of fact, but the key here is that the other party is relying on that statement of fact. So in the widgets example, the company sells widgets. All right, me as the buyer, let's say, of this company, that's important. I'm buying a company that sells widgets. I want to know that they're selling widgets right now. And that representation might go further in a real deal that might say, they're selling widgets right now, and they're going to continue to sell widgets. So it's a statement of fact as of a moment of time intended to induce reliance, right? The other party is relying on that statement that you're making. And it's to establish standards of liability and to allocate risk. And for this one, for a material, innocent, or negligent misrepresentation, avoidance and restitution, so monetary restitution, or you can avoid the contract, right? Because there was a misrepresentation, right? That's what avoidance means. Avoid your obligations under the contract. But for a fraudulent misrepresentation, you can either get avoidance and restitutionary recovery. So to make you whole again, that's all restitution means, and get out of it, the contract, or damages because it's fraudulent. So a little bit different, goes a little bit further. And so benefit of the bargain or out of pocket, and possibly punitive damages, meaning that it was so egregiously fraudulent, so bad, there might be punitive damages available. And that's probably under a specific statute. Question you ask yourself to determine whether it's a representation is, has a party said something on which the other party is relying? Here's an example. This might be in if you're buying or selling a business or something, or assets. The seller has obtained all consents required in connection with the execution and delivery of this agreement. Except as listed in Schedule 3.8, the seller has obtained all consents required in connection with the consummation of the transactions that this agreement contemplates. All right, warranties. Typically, you see representations and warranties coupled together. The definition of it, so usually you see we represent and warrant that XYZ. And it's a promise that a statement is true. So the business purpose is to provide an indemnity, which we'll talk briefly about indemnity in this presentation, if a statement is not true, and to allocate risk. And the remedy is damages, right? You can get monetary damages if someone warranties something to you and it ends up not being true. Has a party said something on which the other party is relying? So similar to the representation, reliance is key. And here's an example of a warranty. The manufacturer warrants to the retailer and the eventual consumer that the products as packaged and shipped from the manufacturer's plant will be free from defects in material and workmanship, and will function and perform in accordance with manufacturer's specification for a period of 1 year from the date of retail purchase. That's your prototypical warranty, but they don't have to be that prototypical, right? That's related to a product that you think of when you think of a warranty. Covenants, definition, promise to do or not do something. So these are those shall clauses. So when you see the shall, it's saying, look, you're going to do that. That's an obligation of yours under the contract. The example here, the seller shall obtain all the consents listed in Schedule 3.8 before the closing. If you don't get those consents, you're in breach of the contract. So the business purpose to require or prohibit action. You're going to do this or you're not going to do something. Again, to establish the standards of liability and to allocate risk. And damages, you might get specific performance, which just means that the courts can force you to do what you said you were going to do, or to force you to not do what you said you were not going to do. So like in real estate, right, it might force you to transfer title to the property. All right, rights. This is going to be a party's entitlement to the other party's performance of a covenant. A right is the flip side of a covenant. So it's the business purpose here is to require or prohibit action, to establish standards of liability, and to allocate risk. The remedy is the same as we just discussed for a covenant. It's going to be damages or specific performance, and it just gives you the option, right? So equitable relief. If the executive breaches her duty of confidentiality, the company has the right to equitable relief, meaning they can proceed with it if they want to. Condition to an obligation. So these are going to be your if-then statements. So the definition of state of facts that must exist. So you're just given a declaration before a party is obligated to perform. The occurrence of the condition must be uncertain, though. So it can't be a certain condition that's already going to happen. So the business purpose is to establish when a party is obligated to perform a covenant and to allocate risk. And it cannot be breached. Its failure to occur means that the obligation to perform is just not triggered. So the question you ask yourself is there something that must happen before another thing happens? Must events occur in a chronological sequence? And as I said before, conditions are usually if-then statements. So the example here, notice, if the owner suffers a loss because of theft or unintentional damage, then the owner must give the insurer written notice of the claim no later than 10 days after the loss. Meaning the owner doesn't have to do anything with the insurance, written notice of the claim at all until the owner suffers a loss because of theft or unintentional damage. So if they suffer a loss that's not theft or unintentional damage, it's not triggered and they don't have to tell the insurer anything in this example. So discretionary authority. Definition, the right to choose what action to take, permission to act. So it says it right there. You have discretion. The business purpose is to provide choice or permission to allocate risk, and there's no remedy here. You don't get anything. But events of default, if an event of default occurs and is continuing, the bank may waive the event of default or exercise its remedies. They have the choice. This is very similar to a right under a contract. So that's the English portion of the presentation. Now we're going to jump into common contract provisions. Things that I see small businesses run into, problems, things that are very common in contracts. We're going to talk through all of those here tonight. So we're going to talk about term, termination, renewal, default, remedies, choice of law, venue, indemnification, limitation of liability, assignment and subletting, and intellectual property briefly. And if you saw my presentation last week where we talked about basic intellectual property provisions, we're going to briefly talk about intellectual property in regards to contracts and assignment. All right. So term, termination, renewal. Very important to small businesses. Why? Because small businesses constantly change, right? What you're doing now is most likely not what you're going to be doing next year or next month even. Entrepreneurs are agile people, right? They take risks. They're constantly pivoting, right? until you are finding out what's working. And so because small businesses constantly change and typically don't have capital to sustain long-term contracts. So, you don't want to get caught up in a contract that's for multiple years if your business might not be in existence, in a couple of years, especially if there's a personal guarantee involved. If you're signing this thing personally, your business might fold, but you might still be liable under the agreement. Very, very important. Anytime somebody asks you to sign personally, you really, really got to think twice about it to decide whether it's something that you're going to be able to sustain if your business fails to perform. So, what do you do? I always advise to, negotiate for short term, month to month is best, right? On any kind of like vendor contracts. You might pay a little bit more, but anytime you can get a short month to month agreement as a small business is advisable. Or if they don't do that, then see if you can't get short termination notice, right? 30 to 60 days, maybe 90 days. So it'll say that it's, a 1-year agreement, but, if you got 30 to 60 days notice, then it's really like a month to month agreement. So this is for an actual vendor contract, and it shows you kind of how tricky things can be. This agreement is for a term of 1 year with a 30-day initial trial period. Okay. And then, so it's a 1-year term. After the initial trial period, the agreement shall start and be automatically renewals. This is one of the things you got to watch out for. Automatic renewals. You might think the agreement's up in a year, and then you get to the end of it and you start, going out there and finding a new vendor for something. And then the next thing you know, you try to say, all right, yep, I'm going to stop payment on this other guy. I'm done, whatever. And they're going to say, oh, no, you got a whole year to go. And what's worse is if you already entered into another agreement with this new vendor, now you've got 2 vendors who you're locked in with, right? So it's very, very important that you make sure that there's no automatic renewals in there, or that you're at least aware of them and what notice is required to terminate an automatic renewal. So in this example, unless either party shall give written notice of termination at least 30 days prior to the anniversary date of the agreement. And typically vendors don't give you, or whoever's on the other side of the contract, any kind of notice about these provisions. And they've already got increases in fees already built in here. So you might think you've got a great agreement, but they've got 3% increase, or what's worse is they'll see, just they can increase the fees at any point throughout. Upon written notice. And what's worse is if it's, a year contract, but then it says something along the lines of, upon 30 days written notice, they can increase the fees. Well, then you're essentially just handing them the keys to determine the price of the agreement. So be very, very careful with these kinds of things. And then, so this ties it, this is kind of interesting too. It ties it to the federal minimum wage increase. Look out for those kinds of things. And just so you understand what you're getting into, right? Understand the terms, and like maybe you might be okay with that being tied to the federal minimum wage increase, or, CPI. But just understand what that might look like in the future. And then otherwise, it's terminated for non-performance only. And that's a high standard to prove, right? Let's say you've got a cleaning company doing cleaning for your small business, and it says for non-performance. Well, they might be doing a shoddy job, right? They might not be doing a good job cleaning your business, and you might want to move on. Well, that's hard standard, right? Non-performance, that means that they're not doing anything that they're obligated to do under the agreement. And just because they're doing a not great job cleaning might not be enough, and likely isn't. All right, default. So these can be defined as events of default, or they might not be defined at all. And so it's just going to be up to the statutory common law, statutory and common law defaults and remedies that we went over before, right? So if it's a breach of covenant, right, damages specific performance, those kinds of things. Those were sort of the defaults that you're going to get for remedies, or that they will get if you're the one defaulting. And typically these, things can be non-payment, bankruptcy, dissolution, reorganization, corporate changes, abandonment, unauthorized disclosure, and all, these are all different kinds of defaults in all different kinds of agreements, right? Non-payment is going to be obviously a default under most agreements. But it's important, how do you avoid these defaults, or how do you set yourself up to lessen the effect or make it at least harder to get there? Set up cure time periods, right? So if it says that it's a payment, you're in default, if you don't pay, try and add some sort of notice and cure time. So, it's an event of default if you don't pay, provided that landlord gives you notice, gives you 5 days written notice before declaring an event of default, right? Those kinds of things to get yourself out of a potential default and down a potential path that is not going to be good. And make sure when you're reading these agreements whether or not they have to give you notice of default. Sometimes they don't. For some of these, you might change around your company and the structure of it, and that might be a default. Under some loan agreements, you can't do that. The bank wants to know who's responsible for the money. You can't, change your LLC to a corporation, or you might not be able to, add on a certain percentage of investors, right? Very, very important, because otherwise they can call it default. Remedies. So these are the things you get, or the other side gets when there is a default. And they can either be defined in the agreement or by statute or common law. So if you're in a default or have breached an agreement, there may be common law remedies or remedies by agreement. Examples of remedies, these are from all different kinds of contracts. We've got some leases here, might just be vendor agreements, eviction, reentry. So those are going to be your lease remedies. Monetary damages, acceleration. Acceleration is just acceleration of the contract. So if, under the whole lease, you owe $100,000 and it's, monthly, it's under 10, right? You can accelerate it even if you're only in, a few months. They can accelerate the whole balance and say you owe all 100 grand, even though you pay monthly. Termination of the contract, attorney's fees, specific performance, and injunctive relief. Injunctive relief is just going to be the court ordering an injunction, meaning they're just saying you can or cannot, usually can't do something, and so it stops that. There's all kinds of different injunctive relief. There's temporary and permanent injunctive relief. In Ohio, though, in most cases in a contract dispute, attorney's fees are only granted if the agreement provides for the award. So if the agreement doesn't say that one side or the other provides for attorney's fees, then they don't get them. So that's, always something you can try and get out of your agreement. Most people will not agree to remove them if they're in there, but maybe they'll agree to make it prevailing party fees. Limited it in that way. Choice of law venue. So all this is saying if there's a dispute, where you're going to litigate, what courts. I would always advise that you try and get this to where your business is located. You don't want to have to try and travel or hire attorneys outside of the state, somewhere else. These are the laws you're most familiar with operating under. It makes sense for you to be domiciled there. So these are what they typically look like. that the laws of Ohio govern all matters with respect to the agreement. Each party submits to the jurisdiction of Ohio state courts. It'll list the county or city that it's listed in. So indemnification. This is probably one of the more complicated and misunderstood provisions in contracts. I see it all the time in small business contracts where whoever has drafted it does not have a good understanding of what it really means. And so this is an attempt to break that down. Indemnification is an undertaking by one party to compensate the other party for certain costs and expenses. Under an indemnity provision, the indemnifying party agrees to compensate the indemnified party for direct claims by the indemnified party against the indemnifying party, third-party claims, or both. And the obligation to defend, this third in the highlight here, is usually broader than the obligation to indemnify because it may apply whether or not the third-party claim has merit, meaning that they have to pay for your defense. So this is an example of a indemnification provision. And essentially, as the first two bullet points say, is where a party would not otherwise be responsible for the damages. This is a provision that says that notwithstanding that that party normally would not be responsible for these damages, that party is going to indemnify me, meaning that they're going to pay for these damages if they come about. So, and then the defense part is that, they're going to also pay for any costs of defense. So in the example, somebody sues me. I've got a third party over here that has indemnified me for this type of suit, this type of claim against me. I go over to them as a contractual remedy. I might still have to pay this person that's suing me, and if they win a judgment against me, it might come out of my pocket first. But then I have a contractual remedy to go after the third party who said that they indemnified me for such thing, right? So an example often in the real estate arena, right? Landlords want tenants to indemnify them. In this situation, landlords would be liable, and it's really taking the liability off of them. So this is sort of a little bit different than the example I just gave, but the landlord is liable in this situation, right? They own the real property. So under property law, if somebody comes in and trips and falls on your property, right, you can be liable for that. And those damages that are caused to that, those injuries that are caused to that person when they trip and fall. The landlord's saying, look, we don't have control over the space. We're not there to police it. We're not there to mop up the messes, etc. So tenant, you should pay for anybody that makes a claim, those types of claims against us. So you'll see an indemnity that says, anything that happens in the premises, you're going to have to indemnify us and pay and then defend us if somebody comes and sues us for a slip and fall in your premises, right? So it's shifting that liability. But again, it's a contractual remedy. It doesn't mean that landlord might be liable. Landlord still has to go and collect. And why that's important is that tenant might not be collectible. And so the slip and fall person is going to sue everybody. And they're going to sue landlord because landlord is liable under the law. Tenant probably is too. And they're going to go get the money from landlord because they know landlord has the money. Get the landlord for money, and then landlord's got to go try and get it from tenant if tenant's not cooperating. And so what that'll lead into next is insurance, right? That's why you see insurance provisions in leases for examples like that landlord will require tenant to carry personal injury insurance like that for slip and fall, so that if landlord can't get the money from tenant under this indemnity, they can go and get it from the insurer. And these are, common in a lot of different different contexts. Again, it's where you're trying to shift the liability that either isn't there or is there, but for whatever reason shouldn't be there. I see these sometimes in like professional services contracts, and it doesn't make sense, right? Good example. Um, they've I see service folks in like the wedding industry and will want the bride and groom to indemnify them for anything that happens at the wedding. That's, of course, the brides and grooms sign it, which doesn't really make any sense because that's not something that they should really be indemnifying the service provider for. Um, it's essentially saying, hey, will you be my insurance company if something happens to me? And meanwhile, the bride and the groom didn't do anything, right? They didn't create a spill. They're not there policing the premises. They are not deciding whether your electricity is adequate to your speakers or something like that. They're there to have a good time, right? So, if they would have, for certain claims, it might make sense, right? If they're asking you to do something like inherently dangerous or something like that, maybe it makes sense to shift the liability to them or something in that example. But I think in most examples, it doesn't make a lot of sense, right? And so in those situations, when somebody wants you to indemnify them and it doesn't make sense that they're shifting the liability to you, that's when you want to push back and say, no, I'm not comfortable being your insurer, right? This is something you should go and get, business insurance for, right? If you're concerned about third parties suing you for something, you should go and get, additional insurance for that. All right, limitation of liability. Limitation of liability provisions in commercial agreements are typically exclude the liability for most or all indirect damages, including consequential damages, and cap the amount of damages for which a party may be liable. Limitation of liability provisions aim to limit a party's cumulative liability, liability under contracts remedy provisions, whether or not these remedies are tailored as exclusive remedies. All right, so liability in the contract remedy provision, including indemnification and product warranties. Parties that bear the most risk in commercial transactions typically insist on a contractual limitation of liability. Without contractual limitations, a party may subject itself to liability greatly disproportionate to the consideration and other benefits it's receiving under the agreement. So what's this mean? Where the agreement is really small, not worth a lot of money, you might see these to really limit what that party might be liable for, right? Sometimes you'll see them capped at like the cost of the contract or a few times the cost of the contract, that kind of thing. A maximum liability or no consequential or indirect damages. So the top paragraph here is an example of where they're limiting any kind of punitive damages and indirect or consequential, like loss of profits, those kinds of things. You can waive some of these. And so that's what's happening here. But you can't waive all of them, right? You can't just say the liability is always going to be shifted from you and under the law. There are limitations to these. All right, assignment subletting. This is going to be lease specific, but assignment, tenant transfers its entire leasehold interest to a third party assignee for the unexpired lease term versus a sublease where the tenant transfers less than all of the tenant's leasehold estate to a third party subtenant. And this may be because the sublease is either or both for only a part of the tenant's premises or for a term that is less than the unexpired lease term. So essentially, assignment is everything, right? They take the liability, they take the whole lease interest, they take the whole lease term, they take the whole premises. That's all, everything, right? And they may or may not be transferring, their liability. They might stay on the hook for it. A sublease is something is smaller, right? There is something is missing, right? There's less of a term. There's no privity as well. There's no privity of contract in between you and the landlord, right? And and so those are the differences between assignment and sublease. But what's most important is A, things like consent, and B, whether or not you remain liable. You're almost always going to remain liable under a sublease if you're the one subleasing. Versus an assignment, you may or may not retain liability to the landlord. And in normal contracts, you can also assign contracts, right? So any kind of other contracts. You can't sublease any other contract, but you can assign any other contracts. Should it allow for that? But don't just think that you can assign any contract without any consequences, right? Assignment might trigger default or attempted assignment or a lot of contracts. So intellectual property. I do a whole presentation on intellectual property, so I'm not going to explain all the different types of intellectual property. Just understand that it's your rights or your business's rights in intangibles, right? Copyright, trade secret, trademark, patents, all those kinds of things. So some intellectual property rights, notably copyrights, and the right to apply for a patent arising out of the provision of the services belong to an independent contractor unless otherwise agreed to in writing by the parties. So what does that mean? That means that if you hire somebody, the copyrights, the right to apply for a patent from those services that you hired them to do remain with the independent contractor. So if you hire somebody to take photos for you and you don't say that you get the copyright, they keep it, right? Very, very important to decide when you're hiring independent contractors to decide who is getting the intellectual property and under what circumstances. So it's important to have assigned all intellectual property rights and deliverables and other work product to the company. All right, so this is a typical intellectual property assignment provision. So all results and proceeds of the services performed under the agreement, so the deliverables, and a whole list of things, right? Inventions, discoveries, processes, techniques, methods, ideas, concepts, right? And patents and trademarks, together with the trade secrets and any other confidential proprietary information, all of that stuff, all of those intellectual property rights bundled up shall be owned exclusively by the company, right? So this is probably some sort of employment agreement or independent contractor agreement. And that anything that can qualify as work made for hire under the Copyright Act is deemed work for hire for the company, and all copyrights therein shall automatically and immediately vest in the company. And this even goes further, and I think there's a right to, it looks like, that anything that isn't work for hire, you're already agreeing to assign it in the future. And some of them even go further and say that you can grant the company a right to be your attorney in fact and go and assign it for you. So be very, very careful around intellectual property. Anytime anything's being created, invented, marketing materials, business name, logo, all of that stuff, make sure you have very clearly who owns that intellectual property. Insurance. All right, we've moved on to insurance. Coming up on the end here. An insurance policy is a contract that shifts risk of specific activities from a commercial entity to an insurance company. So it's just a risk shift, right? You're paying for it. It's another contract really with an insurance company to say that you're going to pay this and you're going to shift that risk, whatever the risk is that normally would be your liability. And so it's really just to shift risk of liability to third parties, property damage, theft, or lost income due to business interruption. And so the insurance provisions that you'll see in agreements will require this. We sort of already mentioned this, in the landlord-tenant situation in regards to indemnification. So, and going back to that indemnity, if you are indemnifying somebody, you need to play out the scenario in your head if something happens and you get a claim and you have to pay for it, is your insurance going to cover it? Do you have insurance to cover it? And then if not, are you going to be able to cover it yourself, right? Or what's the likelihood of these kinds of things happening too? Like that's the other, the business person risk in your mind, right? So be very careful when you're agreeing to indemnify people, because it can really increase your risks that you might not have otherwise had and your liabilities that you might not otherwise have had. And I really encourage you to reach out to insurance brokers to see what kind of coverage you need. All right, so the layers of insurance coverage. There's primary, which is going to be as soon as the triggering event occurs. Excess, which is no broader than the underlying. It's not triggered until primary is exhausted. And for catastrophic losses, it fills the vertical coverage gaps. Umbrella can provide dollar limits in excess of the coverage limits in the underlying policy. So it fills vertical coverage gaps and expand the scope of coverage provided by the primary policy. It fills horizontal gaps. And it's not triggered until the primary is exhausted. So again, these are two different kinds of the excess and umbrella are sort of after the primary coverage. Fill in the gaps. So common types of insurance are going to be your commercial general liability, third-party insurance, cyber insurance, which is becoming more and more important, first-party commercial property insurance. And then environmental insurance, employment practices liability insurance, or sometimes EPLI, directors and officers liability insurance, or people call it D&O, workers' compensation insurance, errors and omissions, business vehicle, and terrorism. Super important for you to have, any small business to have. If you have an employee, right, have workers' comp insurance. If you have a business vehicle, you should have business vehicle insurance. Make sure that it's, your insurance company knows that's business vehicle. Or if you have other people operating those business vehicles as well. Because that's the first, or second people they're going to sue. As soon as they see it's a company vehicle, they're going to come after the company, even if it's your employee driving it. And then, so what's CGL, third-party insurance? This is insurance that primarily protects policyholders from losses associated with third-party liability claims arising out of a company's premises and business operations. So this is going to cover things like third-party property damage and bodily injury. It can also be for personal and advertising injury, so unlawful detentions, wrongful evictions, libel, slander, that kind of thing. It does provide defense and indemnity coverage for the insured business, what we just talked about. Contains a separate section listing exclusions that you should read carefully to understand the extent of the coverage and determine whether the company should purchase additional coverage, right? So umbrella, excess coverage, that kind of thing. And does not cover claims for errors and omissions, workers' comp, EPLI, first-party property. First-party commercial property insurance. This is going to cover things like your buildings, equipment, personal property, and stock, right? So if there's a fire, a building burns down, that kind of thing. Versus CGL, which is going to cover, injury claims, that kind of stuff. Oop. Okay. So, and sometimes related to this and get additional coverage, business interruption, extra expense, civil or military authority, ingress, egress, increased construction costs, all kinds of other additional insurance you can add here. EPLI. So this is going to provide coverage for defense costs and damages for claims that an employer engaged in unlawful conduct against an employee. So think of your discrimination claims, harassment, wrongful termination, invasion of privacy, defamation, slander, those kind of things. All right, so that is the end of the presentation. Looks like we've got about 4 minutes for questions.
I'll put the questions up. We have a question here from Harry. I don't know if this is asking for legal advice or not. You'll have to make that call. Can I terminate a contract for default if they file for bankruptcy? In which situation would this not be possible?
Yeah, I mean, it's hard to tell without seeing the contract, knowing what the state of the bankruptcy is, what kind of bankruptcy it is, right? Is it a reorganization or a liquidation? in those situations, the best thing to do is talk to a lawyer about it. I can't give you specific legal advice, and it'd be impossible for me to give that just with this small set of facts. Um, but you can monitor the bankruptcy case itself. Sometimes those contracts can be terminated by the bankruptcy court themselves, but some of them, if it's just a reorganization, they might continue those contracts. So no, the easy answer here is no. Just because they file for bankruptcy does not mean that the contract is able to be terminated without any kind of remedies.
Okay, there's another question here. This will be the last question for the evening. Ramban Gayatri asks, does terrorism also include riots?
Good question. That might depend on the specific terms. It probably does depend on the specific terms of the policy. So you'd want to talk to your, insurance provider, broker, and ask those kinds of questions, right? Does that include those kinds of? I think it's usually it might even be separate. If I'm remembering correctly, when I've looked at these kind of policy documents, it's not the same. It's different coverage. But good question, and it's something you should understand of what you're covered for, what kinds of things you are covered for, and what things you're not covered for.
Okay, thank you very much, Tyler. This concludes our presentation. Everyone who attended will get a link to the recording. The recording of the webinar will be on our YouTube channel and also on the SCORE website early next week. Wishing you all a happy holiday, and thank you again, Tyler, for a great presentation. And I'm ending the webinar now.